I'm Eric Chester. I'm with Ferguson, Doyle, and Chester. We provide legal services to both the state federation, locals who are affiliated with the state federation, and members, dues-paying members who are affiliated with the state federation. Some of the things, just briefly, some of the things we do a lot of things, but some of the things we do is we represent members who are dealing with investigations related to the Department of Children and Families. We do a lot of training sessions like we're doing tonight. We represent members who get hurt on the job and are fighting the workers' comp insurance companies in a contested case. We do a lot of that. We advise local leaders on potential grievances, arbitrations, contract administration, those types of things. And of course, we provide legal advice to the state Fed on a number of issues. And I think probably the favorite part of our job, what I enjoy most is meeting members like you doing these types of things. Ideally it's done in person. And I miss that. I miss being in the schools and being in the buildings and seeing you guys face to face and hanging out after and hearing the issues that you're dealing with every day. But we'll make the most of what we have tonight. I'm going to cover kind of two big topics. And then if there's time at the end, I'll do my best to answer your questions. One is around COVID and vaccination policies. And I don't know if you saw, but today, within the past couple of hours, actually, the federal government just released a policy. And I'm going to place it in the chat. It's a link to some frequently asked questions about the very recent federal nationwide OSHA policy that applies to every employer with more than 100 employees. And if you, at your leisure, you have nothing better to do, take a look at the link. There's a bunch of questions about who it applies to, who it doesn't apply to. Can you opt out? Can you get testing instead? And it lays all that out. So anyways, I will be talking about COVID, mandated vaccination policies and or testing policies, whether or not you can get accommodations to be excused from those. And then the other thing I'll be talking about is DCF, Department of Children and Families, and how to, what your obligations are as a mandated reporter, and hopefully how to avoid ever having to deal with DCF if you can help it, other than making sure you're meeting your obligations as a mandated reporter. Okay, can everybody see that? Is that good? Okay, great. So we'll talk a little bit about mandatory vaccinations and also a little bit about workers' compensation as well if you ever get hurt on the job or get sick on the job, given what we're all facing. Okay, so the million-dollar question really is that people ask all the time is, can an employer mandate vaccinations? The answer is yes, they can. And there have been recent cases that have challenged this on constitutional grounds, and there have been a handful of decisions. This is a relatively new issue, but in the 4 or 5 cases that have gone the distance and have resulted in a decision from a court, they are 100% unanimous that yes, employers can implement mandatory vaccination policies. They don't violate anybody's constitutional right to require vaccinations. They do, however, require that there be, that there be the ability to have either a religious accommodation or a disability-based accommodation. And I'll talk a little bit about each of those. So the first one is an accommodation based on a disability. Under the ADA requires that a reasonable accommodation be made or offered unless the employer can demonstrate that that accommodation would present an undue hardship on the employer. So in your run-of-the-mill physical disability, you can't go up and down stairs. It would be an undue hardship on the employer to have to build, a ramp, let's say, when they have an elevator. or conversely, it certainly would not be an undue hardship on an employer to allow an employee to use the elevator, to give that employee an elevator key, or allow them to park closer to the building. Those would certainly not be undue hardships on the employer. Now, under these vaccination policies, and as they relate to COVID, the employer can have what's called a qualification standard. And what that means is that if the individual poses a direct threat to the health and safety of individuals in the workplace, that could be the undue hardship. The employer could say, look, allowing this person to come to work unvaccinated poses a direct threat to the health and safety of other workers. That would be an undue hardship on us. We're not going to accommodate that person. That can be the case. Same thing for this, what's called a safety-based qualification. Would the employee pose a direct threat due to a significant risk of substantial harm to the health and safety of the individual or to others? That can't be eliminated or can't be reduced by a reasonable accommodation. And again, it's a balancing test. It's the undue hardship versus, or the risk of harm weighed against the accommodation. So, for example, we don't see this too much in the schools, but where we do see it a lot is in healthcare facilities. We've had some hospitals that have just said, look, if you're a healthcare worker in our hospital, especially if you're a nurse and you deal with patients, you being unvaccinated poses a significant risk to the health and safety of the patients, and we can't reduce that risk through an accommodation. And therefore, it poses an undue hardship that we can't get around. Therefore, we cannot accommodate you. You work face-to-face with patients. Now, I can see an employer, I can see a Board of Ed saying the same thing. If you're working face-to-face with students, can they accommodate someone by not allowing them to be vaccinated and give them that accommodation? And would that still pose, a direct threat to the health and safety of others? And it could. And I think an employer would most likely prevail in litigation if they took that approach, that look, you're dealing with younger children who are not yet vaccinated, and you being unvaccinated poses a substantial risk of harm to those kids. We can't accommodate you. You have to get vaccinated. That can and does happen. This is a question we get a lot. Someone asks for an accommodation under the ADA, a disability-based accommodation. We get the question a lot, well, can my boss, can HR talk to my doctor? Can they ask me for medical information? The answer is yes, they can. Do they get to see your entire medical file? No, they don't. And you do have certain rights of privacy and protect your private medical information. However, when the employee is asking for an accommodation based on a disability, the employer needs to know, okay, what is the disability and how can we accommodate it? So they are allowed to inquire as to, okay, what is it he or she can and cannot do, because they do have an obligation to try. An employer does have an obligation, a legal obligation, to see if an accommodation can be arrived at. They do. And so for them to see if they can do it, they need to know a little bit about what is the cause of not what's the cause of the disability, but what is the disability? And so that may require them speaking to your doctor, asking your doctor to complete certain documents and have a dialogue to see what can be done for that employee. But again, you don't have to sign a release that allows them open access to your entire medical file. You do not. The next type of exemption, so you have the disability exemption under the ADA. The next one is the religious exemption. And before I talk about the religious exemption, I will say that I have yet to see a an application for a disability-based exemption for the COVID vaccine. There really isn't one. There is no medical condition that I've seen that would require an employee to need an accommodation and not be vaccinated. The vaccine is medically safe. There really isn't a diagnosis that would prevent someone from being vaccinated. There have, however, been a number of applications for religious exemptions. That's the other type of exemption that might apply to a vaccination policy. And this isn't governed by the ADA. This is governed by Title VII of the Civil Rights Act. And employers cannot discriminate against employees based on their sincerely held religious beliefs. And the accommodation, it really comes down to the same test. Is the requested accommodation, does it present an undue hardship on the employer? Can they do it? Or is it just impossible for them to do? Courts have held that deeply held religious beliefs are given broad discretion. So in other words, it doesn't have to fit neatly into a specific, identified religion. So there is some broad discretion as to what qualifies as a deeply held religious belief. But if there is no accommodation possible, then the employer is allowed to exclude the employee from the workplace, to let them go. But just like with the disability accommodation, the EEOC, the Equal Employment Opportunities Commission, in their guidance says that the employer has the same legal obligation to make a good faith effort to see if an accommodation can be made. And what I will tell you, for those of you that are, maybe building stewards or local leaders in your union, unions do have a role to play here. If an employee is seeking a religious exemption from the vaccine, they want an accommodation, they want to be able to have weekly testing, they want to be able to wear a mask and not be vaccinated due to a sincerely held religious belief, they make that request. What should happen under the law is that the employer, whether it's HR, whoever it might be, should be, engage the employee in a dialogue, in an interactive process. And a union can be involved in that, can be a support for that. And so when you're having a meeting with HR, it's perfectly fine for the employee to say, listen, I would like a representative of my union there with me in this meeting. And so you maybe can work through and see if an accommodation can be made. And again, whatever the accommodation is, if one can be made, of course, the employee would still need to be able to do the essential functions of their job, even with that accommodation. Now, where employers get themselves into trouble is if they get, let's say they get 10 applications for religious exemptions, right? And HR sends an email out to all 10 the day after they got the applications saying, we've looked at it, your request for an accommodation is denied. And the person say, wait a minute, I thought we were going to have a dialogue. I thought there was going to be an interactive process. I thought we were going to have a sit-down meeting to talk about this. And none of that happens. Employers can get themselves in a bind by doing that. That's really runs afoul with what the law requires. It means they didn't take the request seriously. They didn't engage in the interactive process. If that happens, the remedy there would be for the employee to file a complaint with the CHRO, the Connecticut Commission on Human Rights and Opportunities. And again, I'll say this, that most likely the relief, the remedy you would get is that CHRO would tell the employer, hey, follow the law and engage in the interactive process. It doesn't mean that you would necessarily get the accommodation that was requested. It would just mean that the employer has to follow the proper process in coming to that determination, okay? Okay, before I get to the next topic, any questions on exemptions, requests for accommodation from a vaccination policy?
If somebody already asked for an exemption on something and it's something they already addressed, and then somebody else doesn't know that they've already gone through the process of denying the request, can they, if a new employee requests that disability based on religious beliefs or whatever, could they then tell that employee, we've already tried to find an alternate plan and we don't have one, so that the employee isn't feeling like they're just shoved off?
Yeah, good question, Linda. I would say no, because you don't know. You don't know until you hear from that employee what it is that may or may not be able to be done for this person. So if you're a one-to-one para who works with young children who are not eligible to be vaccinated, and the employer says, look, we can't accommodate you. You have to be vaccinated. You work with kids who can't get vaccinated, right? There's no accommodation we can make. And then another employee comes in a couple months later, and I don't know, maybe that employee is I don't know, a school psychologist, you know, and maybe they can offer therapy sessions over Zoom. Maybe an accommodation could be made for that person. You know, every job's a little different, every person's a little different, every situation a little different. HR should not be coming out with a one size fits all, because different jobs have different requirements. So maybe some people could be accommodated. You know, I could see the one-to-one para saying, wait a second, why are you able to accommodate the school psychologist, but not me? And I think that the two scenarios I gave you would probably be, you know, maybe justified in that. So no, they shouldn't send out an email, we've already looked at this and we said no to that person, we're saying no to you too.
Thank you, that makes sense.
Sure. Okay. All right, so Executive Order 13G, I think all of you are familiar with this. School applies to all school board employees, that's everybody, both public schools, non-public schools, teachers, paras, school nurse, social workers, etc. This is the vaccination policy and/or testing policy for all school employees. It does allow the employer to request, I should say employer, allows the employer to request proof of vaccination or proof of testing results. I've had a couple people, not many, say, wait a minute, that's my private medical information, that's a violation of HIPAA. It's not, it just isn't. Employers are allowed to ask employees, hey, let me see your vaccination record, or for those that allow testing, you have to produce a weekly negative test. Now, I will say that if a parent were to say, I want, under the Freedom of Information Act, I want to see which of my kids' teachers are vaccinated, which ones aren't. They're not allowed to have that. And the school isn't allowed to forward that information. So schools, the employer is allowed to ask because they need to try to maintain a safe workplace. They're allowed to ask for that information. They're not allowed to hand it out to people who ask for it. Typically, you know, information documents that are held by the Board of Ed, those are public documents, they're public employers. And usually a public employer would have to disclose that information under the Freedom of Information Act, but here, no. The executive order was clear on that. That information is not to be disclosed to the outside. All right, just a couple of things on workers' comp. First off, any employee, any member of AFT Connecticut who's a dues paying member gets hurt on the job and has their claim denied, has a workers' comp claim denied, they get the benefit of free legal representation through our office in advancing their workers' compensation case. That doesn't mean, though, that we represent everybody who had an on-the-job injury, because believe it or not, in the majority of cases, you get hurt on the job, you fill out a claim, it gets accepted, you get the treatment you need, you get the benefits you're entitled to. We wouldn't be involved in that. We get involved if you get denied. So if a dues paying member gets a denial of their comp claim, then by all means, you let your union leadership know, they get us involved, and we pick up the case and make sure you get the benefits you're entitled to. And just basically under workers' comp, you know, it's supposed to be a non-adversarial system. You get hurt at work, you get sick at work, and because of work, you file a Form 30C. You got to do that. Every union leader should have that. Those Form 30Cs are available online. You have a year to file your claim. I don't advise that you wait that long. You should do it soon. I will say that the biggest mistake that we see happen is that an employee will fill out an incident report, right, that you're required to do, and think that that initiates a workers' comp claim. It doesn't. It doesn't. You still need to file that Form 30C. And again, those are available on the workers' comp website. Ideally, there should be a stack of them, in the union stewards, teachers lounge, wherever. And you fill one of those out when you get to it. You don't have to do it right away, but soon. And that keeps your claim active, keeps your claim open. You also need to seek medical attention for the injury or the illness right away. If you get hurt at work, you should go from work to Occ Health and get the treatment, okay? You should do that. Now, one question we get asked a lot is, can I go see my own doctor? The answer is yes. You can always go see your own doctor. However, you have to let the employer fix you, right? You have to let them try to make you better, to treat the injury. So you shouldn't skip Occ Health for your doctor, but what I'm suggesting is you could also, after you leave Occ Health, not 100% happy, you want a second opinion, you can always go see your own doctor, okay? This is what a Form 30C looks like. Again, they're online. I think they're on the AFT Connecticut website as well. You fill this out. It's a brief explanation as to what happened, and you're off and running. And your claim is alive and well. Now, the denial of a workers' comp claim comes in the form of what's called a Form 43. They have to send you this in the mail if they're going to contest your claim. And that's when you would get us involved. The employer has 28 days to contest your claim or else they own it. Now, there's some pros and cons about this. What winds up happening, unfortunately, is because they only have 28 days to respond to the claim or else they own it, they typically deny most claims until they can figure out whether or not they're going to accept the claim. So 28 days to you and I sounds like a long time. To an insurance adjuster, it's a short period of time. They haven't had the time to investigate the claim. They haven't had time to see if maybe there's some kind of underlying condition around the claim. So what do? They rubber stamp a Form 43 to contest the claim, just in case they want to really contest the claim later, if that makes sense. So if you get one of these, you let us know. However, what a Form 43 does is, let's say you get hurt at work. Let's say you think you contracted COVID at work. You fill out the Form 43 and I'm sorry, you fill out the Form 30C and then you get this Form 43 a week later. Like, what? How can they deny my claim? Well, again, remember, they're probably denying their claim to preserve their position before they run out of time. That's probably the basis of the 43. But what that's going to mean for you or for the injured worker or the sick worker who caught COVID at work, what do you do for treatment? Well, what you do for treatment is you see your doctor, and your doctor's going to ask, is this a workers' comp claim? You're going to say yes. And they're going to want to bill it through workers' comp, but you have a Form 43. So what that does is it tells your doctor and it tells the person who does the billing at your doctor's office to bill it through your own insurance because the claim is contested. So you would bring that Form 43 with you to your doctor's office. You give it to the person sitting at the counter who processes the claims and payment and so forth. Say, look, here's the Form 43. Can you process this through my own insurance for the time being? And they have to do that. They have to. So you give them the Form 43, you give them your insurance card, they process it through your own insurance. What you're going to want to do is you're going to want to keep track of any out-of-pocket expenses, any copays you had to make, because you're going to get reimbursed for all of those once your claim is accepted. Once we get your claim accepted, you get reimbursed for any out-of-pockets, okay? So that's kind of how that works. Because the last thing you want to have happen is an injured worker can't get into the doctor's office because their claim is denied. The denial gets you into the doctor's office. It just means that payment for that treatment is going to have to go through your own insurance for the time being until we can get your claim resolved. Again, keep receipts of any out-of-pockets for prescriptions. If you had to take pain medicine for a back injury, if you had to take antibiotics, whatever it is, keep that documented. We'll get you reimbursed for all of that. I think this is what I just spoke to about that. Just went over this. Make sure you're getting the medical treatment and medical attention. You're documenting it, documenting any out-of-pockets. And then again, you contact your union leadership about requesting legal assistance. If they're really contesting your claim, okay, it's not just we want to contest it because we don't want to miss the 28 deadline, but they're really contesting it, they could send you to another doctor. You have to go. They're going to ask that doctor, hey doc, do you really think that this injury happened at work? You need to go and keep those appointments. We would typically request a letter from your doctor. Hey doc, remember when you saw this patient a week ago? Do you think the injury happened at work? Do you think the symptoms she's suffering from are related to the work-related injury? Your doctor's going to say yes, and we'll be in good shape. If their doctor disagrees with your doctor, sometimes workers' comp can send you to a commissioner's exam, which is kind of like a tie-breaking doctor. That can and does happen, in kind of more significant cases.
Eric, have you had any of the COVID cases come up yet?
Yes, a number of them.
And are we seeing that they are ending up as workers' comp claims, that go through?
Sure. So we've seen a number of them, most of them in healthcare facilities. I don't know, Carol, as I'm thinking off the top of my head, we've had over 30 COVID workers' comp cases, maybe 32. I'm trying to think if we've had any in education. I think they're all in healthcare. Yeah, but the ones we've had in healthcare, a couple things happen. One, they will say, okay, look, we're not going to accept the claim, but we're going to pay them all the benefits as if we've accepted the claim. And if the person's okay with that, then we're okay with that. Claim stays open. They don't walk from the claim, but they get all the benefits they're entitled to under comp. Missed time from work, treatment, et cetera. Reimbursement for out-of-pockets, they get all that. Mm-hmm. And then we've had some where they said, yep, we accept the claim. Yep, they got COVID at work. Doctor's reports are all there, the exposure, the test, they've been nowhere else. The nurse worked in the hospital, went home. They can't prove that she didn't get it at work, and we've prevailed in those. And then we've had a couple where we've had to go the distance on. We've had a trial, and we're waiting on decisions on those. But in the vast majority of cases, we can get it resolved.
Yeah, the district has kind of given us the idea that you have no basis for a claim if you end up with COVID. And many of us work within inches of children who could possibly even not be masked and obviously sure. Not vaccinated. Mm-hmm. But they've kind of given us the feeling that there's no claim there.
Well, they may give you that feeling, but that's not what the law says. COVID is covered as an occupational disease, like anything else. If you have an exposure, a known exposure, document it, incident report, whatever it is. If you get one of those letters saying you had a close contact, right? Keep that close. If you then test positive for COVID, file a Form 30C.
So here's the trick. New Britain is not identifying anyone who has COVID. They're asking all staff that has a classroom or whatever to post their seating plan in the classroom. They also have it in the administrators can access through Google So they don't tell you that you've been exposed.
Mm-hmm.
And their reasoning is, if you're vaccinated and you feel like maybe you have COVID, you need to go get tested, and that's the only way that you're going to be staying home. So in other words, you may come within inches of a child with COVID, and unless you show symptoms, they don't care.
Okay, well, a couple things on that. There's two different issues you're raising. One is, whether or not the workplace is safe enough, right? And that's certainly important. The other is whether or not you have the basis of a workers' comp claim to assert that you contracted COVID at work or as a result of work.
Right.
Look, if you think you've been exposed at work and then you test positive, file a comp claim, file 30C, and just document the date of the suspected exposure. I think I was exposed to a kid unmasked who wasn't vaccinated. And you know what? That kid was out of school for the next 10 days. And the reason was, guess what? He was a positive case. And I was with him on this date. The kid wasn't wearing a mask. And guess what? 5 days later, I tested positive for COVID. You can connect those dots.
Yep.
So file it. Go ahead and file it.
In my case, I'm an inclusion para. And so I go from class to class to class.
Mm-hmm.
Again, I work very closely with students, but both myself and the student are supposed to be wearing masks.
No, I understand that. I understand that. And listen, I have a bunch of slides to get through, but listen, at the end of the day, if you have an exposure, even a suspected exposure, file the 30C.
Okay.
And you have to test positive, of course.
Right.
You need a positive test or a diagnosis. So if you go to your doctor, you have a fever, you lose your sense of taste and smell, but you tested negative anyways, you can still get a diagnosis of COVID. There have been some false negatives. We've seen those.
Yep.
So either a test or a diagnosis of COVID, and you have an exposure and you can connect those dots, file. Okay.
Thank you.
Sure, you got it. I'm gonna skip that. Okay, so we're gonna go to DCF for the next part of this. Okay, can everybody see that? Guy burning at the stake? Okay, so in the next just 20 minutes or so, and I apologize if we're going through this too quickly, and I do want to take questions at the end. I'll talk a little bit about your responsibilities as a mandated reporter, and then what to do if you wind up being investigated by DCF, and then representation of members who are being investigated by DCF. All right, so first of all, who is a mandated reporter? It's you. I can't stress this enough. We had just this week, we've given this training dozens of times to hundreds and hundreds of members. Just this week, we had a case where a para, who was a mandated reporter, suspected abuse and neglect, and she told the school social worker. That's not, you can't delegate that responsibility. The para who suspects that abuse and neglect is happening is the mandated reporter. She's got to call DCF. But she didn't. She told the school social worker. And guess what? The school social worker did. She told the principal. So now we got two people who are passing along the information. Both are in hot water now because both were mandated reporters. The para should have called the DCF hotline. The school social worker should have called the DCF hotline. Neither did. Both are being called to the carpet on it. Okay, so please do not sending an email, sending a text to the teacher, to the school social worker, to the administrator does not meet your obligations as a mandated reporter. You can be severely disciplined. Your license could be on the line. There are serious implications. And the state legislature is now looking at even making harsher penalties for educators who fail to meet their statutory obligations as a mandated reporter. Don't let that happen to you, please. What gets reported? A reasonable cause to suspect or believe that a child has been abused, neglected, or is in imminent risk of harm. Kid comes to you and says, I don't want to go home. The babysitter touches me. You got to call that in. You got to call that in, keep the kid, don't let the kid get on the bus, call DCF, call the hotline. Now, it's certainly fine to go into the social worker's office and say, hey, this kid just told me something. Let's call DCF together. That's great. That's fine. But what you can't do is you can't go into the social worker's office and say, hey, this kid just discloses to me. And the social worker tells you, I got it. I got it. Thanks for letting me know. I'll take care of it. No, don't leave that social worker's office. You stay in that social worker's office. You stay in that administrator's office. You get on speakerphone and you call DCF right then and there together. And you make the report over the phone together. That's perfectly fine. But you don't let anybody tell you, I got it. I'll take it from here. You'll be in big trouble. Even if they do take it from here, you'll be in big trouble because you can't delegate that responsibility. How do you make a report? You call the DCF hotline. Number's right there. It's online. Now, you need to follow it up with the DCF form 136. That can be sent in by someone else. Doesn't have to be sent in by the person who made the report, whether it's the school social worker or the administrator. You want to make sure it does get sent in. And I think now it's 24 hours of the oral report, but you want to make sure it does get sent in, but it doesn't necessarily have to be the same person who made the report. So yeah, don't let the time go by. Make sure the report is made. If you fail to report, again, I think this law is going to be changed. I think the punishments are going to be harsher, but you could be sued for failing to report. And this is willfully failing to report. In other words, you think abuse or neglect is going on, but you say, you know what? I'm not getting involved in that. That's a family matter. I'm looking the other way. You could face civil liability for that. You could certainly lose your job for that. You could also, it's not on this slide, if you're a certified teacher, your license is on the line for that as well. And you're subject to a fine. And there's criminal liability now as well. You could be arrested for willful. Again, this would be a case where the person did suspect abuse and neglect and said, you know what, I suspect it's happening, but I'm choosing not to report. If you make a report, it turns out the report you made was not true, you are insulated, you're protected, you're not going to be sued, and you're going to be immune from any type of civil or criminal liability. So kid discloses something to you, uncle's doing something that she doesn't like, you make the report, turns out it's not true. Now the uncle wants to come after you because, you've embarrassed him, he's been shunned from the family, etc. You are going to be protected. The only time you're not protected is if you knowingly make a false report. I never liked this parent, I'm reporting them to DCF. You can't do that, of course. All right, before I go on to the next slide, any questions on your obligations as a mandated reporter? Okay. The only other thing I'm going to add to that is, everybody, we're all in this for the kids, paras, teachers, social workers, school psychologists, administrators. Everybody's in it for the kids. Everybody's a mandated reporter. A lot of times in classrooms, a lot of times in your inclusion classrooms, you have a teacher, you might have a couple paras, maybe more in the same classroom. I share this with you. My wife is a special education teacher. She teaches in a classroom with profoundly disabled students. She has lots of paras. And some of them have been in her room for years and they know each other's families. We've had them over. We've been over their homes. We know their kids. You work with people for a long period of time. You get to know one another. You develop friendships, close friendships. That doesn't negate your obligation as a mandated reporter. It doesn't. And also, it doesn't mean that someone isn't going to report you. So what I say is, if a teacher loses her cool with a student, she's reached her wit's end and she grabs a kid, and that teacher thinks to herself, I've had these 5 paras in my room for a decade. No way they report me. That's not the case. Okay, it can't be. It can't be the case. We're all mandated reporters. So we all have that professional and, quite frankly, that legal and moral obligation to report. All right. Okay, so let's shift gears a little bit and turn to what happens if the report's made now against you or one of your colleagues. It sets off a process that's going to run its course. The report's made. DCF is going to take the case. If they decide to take the case, they're going to want to interview the kid. They may interview the kid's parent. They may interview other adults who may have been in the room. They may interview the person's supervisor, the administrator. The last interview they're going to do is of the alleged perpetrator, person who is alleged to have committed the abuse or neglect. It's going to be the last interview. That person, no member of AFT Connecticut should ever meet with DCF without one of the union lawyers present. Okay, you're under no obligation to meet with DCF ever. We've had a couple cases that haven't happened recently, but in the past, a couple of years back, there have been times where the DCF investigator showed up to the teacher's home, knocked on their door, and introduced themselves as a DCF social worker, and said, "Do you mind if I ask you a few questions about Johnny?" "Sure, come on in." Now the DCF worker is in their home talking about Johnny, and lo and behold, they're not talking about Johnny. They're interviewing this person to see if there was some neglect. Maybe the person didn't report something. Don't ever let that happen. If you're ever contacted by a DCF worker and you're the subject of the investigation, you tell them that you're not speaking to them until the union lawyer is present. Okay. Now, the only difference is if you're being contacted by DCF as a witness. If you saw something, you were present in the cafeteria during an incident and DCF wants to take your statement, then yeah, you wouldn't have a lawyer there with you. You may not have a union rep there with you. You're just, I was there, here's what I saw. And you give your statement. It's not you who's being investigated. In that case, you wouldn't have legal representation. You're being interviewed as a witness. But if you're being interviewed as the person who the investigation is being focused on, then yes, you need legal representation there. So when that happens, what you're going to do is, if you're contacted by DCF, the first thing you're going to do is tell them, "I'm not speaking to you." You contact union leadership right away. And union leadership will contact us, and then we'll reach out to the member. And, okay, what's going on here? What happened? And we'll prepare that person as to how they may or may not want to answer certain questions. I'll say this, I've done hundreds of these now. And so have my James and Jim, who also are lawyers in this office. Thousands of them now over the years, probably. It's really important that the teacher, the para, whoever it is, listen closely to what the allegation is, and then keep their responses concise, and not expand upon things. Now, one thing that comes to mind is what can and does happen is there's an incident and the administrator contacts the para and says, "Can you send me an email as to what happened during second period today? I want you to provide a statement." And you're thinking to yourself, "What happened during second period?" And you're not sure. And so maybe you send an email, "Okay, here's second period. We did this. We had reading time. We went outside. That's it." Yeah, okay, that's fine. But maybe something did happen during second period and you're not sure. Maybe the administrator says, "Hey, did you have to break up an fight between these two kids?" "Yeah, I did." "Oh, can you provide a statement? Can you send me an email? I need a statement before the end of the day." You would need to comply with that request. You don't want to be insubordinate. If your supervisor, your administrator says, "Can you write up what happened?" you would need to do that. But I think you probably want to reach out to your building rep and say, hey, look, I was contacted by administration. They want me to write up something that happened. You know, kid came into my room during prep, and now the kid's saying that this happened while he was in my room alone with me. Okay, talk to your union rep about that. It's okay to have them look at your statement first, you know, and maybe review it. But you do need to submit it if you're directed to submit it. What I would suggest is just keep it concise. Here's what happened, and nothing else. And that's it. Don't get into, oh, I think I know why this kid's making this up, or don't get into that. Keep a copy for yourself, of course. Okay. Now, before I move on to the next slide, what happens, every district's a little bit different, and every case is a little bit different. But what can happen is the person's put on unpaid administrative leave during the investigation. That happens. And again, different districts handle it differently, and different cases are. If it's a serious case, they may put the person out. That can happen. That can happen, and it's sad. And the person is on an island, isolated from their colleagues, and they feel alone. In that case, just know that you're going to have union representation when you're called in for a meeting. So, you just kind of have to hang tight. If DCF is going to be involved, we're going to be involved, and we're going to be there sitting side by side with you when you meet with DCF. Just know that. And if you're going to be called in for a meeting with HR, your union rep's going to be there with you, representing you. Okay, at the end, when DCF has concluded its investigation, if there's a substantiation, they're going to send the person a notice. That wouldn't be good if the person is substantiated. But what is good is if you're a dues paying member, we file an appeal on your behalf and at no expense. And we get a vast majority, an overwhelming majority of them overturned. So it is a huge benefit of being a dues paying member to your union. It's at no expense. It's an administrative trial that we've had a lot of success in over the years. I think in the 20 or so years that I've been doing them, I've had maybe 20 of these trials. I lost one, and that was because during the middle of the trial, my guy stood up and threatened the DCF worker, "I'll get you." So we lost that one. But in the others, we prevail, and it's not because of any fancy lawyering. It's because 99 times out of 100, there's an explanation, right? That the person didn't do what they're alleged to have done, or it didn't go the way that the investigation suggested it went. So in any event, but what's important to note is that, you're really dealing with two different entities, right? We can get the DCF thing reversed, but you also have your employer to deal with. And they may want to do something. So, DCF is obligated to investigate whether or not abuse and neglect happened. And there are certain standards they need to meet to prove that there was abuse or there was neglect. Your employer doesn't have to meet those same standards. They may find, well, okay, DCF concluded that this didn't rise to the level of abuse and neglect. However, we don't like the way you handled the situation, or we think it violated one of our policies. And they may want to call you in for some type of corrective or disciplinary action. And that certainly can and does happen. But if we can get DCF to conclude that there was no abuse or neglect, that certainly does help with dealing with the employer, right? We tell the employer, look, DCF said there's nothing here. Let's get this person back to work and put this behind them. And that happens a lot. But every once in a while, there may be something that happened that the employer just didn't like the way it went down. And even though DCF exonerated them, or at least found that there was no abuse and neglect, the employer says, we're not comfortable, we want to bring them in. And so that can happen. Okay, so just some kind of takeaways to leave you with. When in doubt, if you think there might be abuse and neglect, report it. Never rely on others to file a report on your behalf. If you're ever under investigation, immediately contact the union, okay? Union members, dues paying members have access to the union attorneys for DCF investigations. These are things I'm sure you guys already know and you practice every day, but keep physical contact to a minimum with students. For you paras who are working one-on-one with students who require physical prompts, you do hand over hand kind of stuff, that physical contact is always permitted, and that's fine. But it should be part of their plan. If there's going to be prompting that's going to involve physical contact, that should be hopefully identified in their IEPs. So you're always going to be okay. Tapping a kid on the shoulder to get his or her attention is always okay. But keep the physical contact to a minimum. Document incidents, when they occur, keep a copy for yourself. If for nothing else, it's fresh in your mind. You write it down when it happened or after school. Let your supervisors know if something's happening, put them on notice. Kid's being overly disruptive, his behavior is deteriorating. Let somebody know about that, and something should be done about that. Same thing with dealing with the social workers or any behaviorists. They have a job to do, and you should make them aware of issues and make them do their job. So keep those lines of communication open. And I was told I should probably end around 6:15. So it's 6:09. I have a few minutes to take any of your questions.
Eric, I had a question with, we had some neighbors that moved in and we were having things we were observing that really we shouldn't have been observing. And we did end up contacting the police and DCF and things like that. But I had spoken to the social worker at my school to try to get her to contact the social worker at the boys' school out of concern for the students. And the odd comment that came back to me is I knew I wasn't going to ask any information, but my social worker said they did figure out who I was talking about and obviously couldn't give me any information, which I didn't want. But she said, the social worker at the boys' school said, just remind her she's a mandated reporter herself. And I feel like if you're not in your environment and you're just in your everyday life, that obligation is not on you.
That's true.
Okay.
That's true.
That's what because I was like, I originally years ago, they said, once you're a mandated reporter in all aspects of your life. And I'm thinking, that's got to be near impossible. You go to a store and you see something and but anyhow, so I am correct where the social worker was implying it was my duty to call because it was my next door neighbor.
No.
Okay.
Now, should you? Yeah.
I did.
But yeah, and you probably did the right thing, but legally you have a legal obligation as a mandated reporter to report suspected abuse and neglect of a kid that you're not responsible for. It's outside the context of your role as a school social worker. Then no. Okay. No, you see a kid, acting up in the grocery store and the mom whacks him. You don't have to call DCF. Well, thanks again for having me. Thanks again for taking time out of your day. Just know that, if you're ever in a pinch, your union's got your back, and stay safe and be well.
Thank you, Eric.
Thank you. Thank you.
Thank you.
Thank you all for coming. I did find that legal issues survey link. It is in the chat. But I will have Anna send it out as well. And Eric, if you could send me the slides. Some people were asking if they could have the slides for themselves as well.
Certainly, happy to.
Excellent. All right, guys.
Thank you, Rosemary.
Thank you.
Thank you.
Have a good night, everybody.